Houston. We do bring in immigration updates every Tuesday from 5 to 6 p.m. We take live questions. Along with me is my business partner, Stephen Brown. Stephen, what do we have today to discuss?
Yeah, Rahul, we're going to talk about a couple of big topics here. Marriage-based green cards. If we're going to see more couples getting denied or deported under some new policy guidance that's out there, we'll talk about that. We'll give updates to the NTAs for H-1B workers that are taking actions while they're in the grace period. We'll also talk about the current push by the administration to get IRS payroll records into immigration authorities' hands and what scrutiny we might be seeing from that. And then we're going to also talk about the Dignity Act. That's up at Congress. It's a renewal of the 2023 Dignity Act, and we'll talk about what's kind of in it, and what to expect on that.
Okay, first on the marriage-based green card applications, there have been a couple of updates. They made it more stricter for the people to prove that their marriage is genuine. They have categorized that anybody who has certain aspects, they would be calling for interview, which was in general, they were calling for interviews too. But what was surprising to me, Stephen, is that you, me, and Emily have been telling all along that if the person is out of status also, they can still get the green card if they are married to a US citizen, as long as the marriage is genuine. That's what we told previously. However, USCIS now says that if the USCIS finds that the person is not maintaining the status or out of status, they can issue a notice to appear, and the case will complicate it, where the person has to go to the immigration court and request the immigration court to put it back to USCIS. It's going to be a very expensive process, though. So
Yeah,
that's
go ahead.
no, that definitely is becoming a big problem because just to get the same thing done, you have to file with the immigration, then you have to go to the immigration court, and who knows, they may even detain this person for temporarily until the immigration judge gives a bail, and then afterwards you move it back to USCIS and then get the things adjudicated in USCIS. This is we're only speaking about genuine marriages only. Go ahead, Stephen, you're speaking something.
Yeah, I mean, it's still going to work out, I think, in the long run. Somebody who's entered with inspection, you entered the country lawfully, maintained status, and then you lose that status. Or technically, typically under the, immediate relatives, everything gets cured with that. But again, because what we've seen in the last few months, USCIS has kind of taken new looks at everything. It just might be something to be aware of additional hurdles you might need to go through. And when you have an administration, Rahul, that's all about removal numbers and arrest numbers rather than, actually getting all the bad actors the way they kind of campaigned, good people are going to get caught in the crossfire.
I would say that it will become 3 to 5 times expensive if somebody has not maintained the status, or I would even say even more, and very stressful for the people to get the green card. It's going to be expensive for the immigration, the government also to deal with, because eventually they will have to give the green card to this guy. Why give the person to go to immigration court, ICE, Immigration Customs Enforcement, come back to USCIS and still give them the green card? However, as we know that the big beautiful bill has the extra $110 billion. They have the budget and they're using against these individuals unnecessarily to create hurdles. But well, that's what this administration is right now. But anybody who is planning to file an adjustment of status who has ever violated the status, definitely they need to be very careful when filing this application. Anything else,
Yeah,
Stephen, before?
yeah. I mean, if
Sorry,
you
go ahead.
think about this, Rahul, something it has been a big theme of mine throughout the last 6 months is, this is a win-win for the administration, as bad as that sounds. If, for whatever reason, they're able to go through the removal process and the individual gets removed, that accomplishes a goal of the administration. If it doesn't, all they have is an increased statistic on arrest and how many people are in removal proceedings, that also plays well with the talking heads on the news that the administration likes to get on. So even if the removal fails in this case because the individual, the law allows this, um, then it still counts as a win in their book because they can go on the news next week and be like, we have X number of people in removal proceedings. It's an increase of 150%, and Joe Biden wasn't doing this. And that's what they're trying to do right now.
One major problem I have, Stephen, is that I've seen some immigration judges got fired recently. As you
Mm-hmm.
know, some of them are getting laid off. I don't know what's the purpose for them to lay off when there's so
Oh, I
much
do.
demand for it.
I do.
Okay, tell
I
me.
mean, yeah, immigration judges are Department of Justice employees. They're not Article 3 judges. When we go to federal court, we're in front of an Article 3 judge that the president nominated, the Senate vetted, and confirmed for that position. The immigration judges are Department of Justice employees that have the title of immigration judge. They're administrative judges, all right? And they fired a bunch that were Biden hires, or Obama holdovers, so they can put in more of the people that are going to be in line with the current administration and their thinking. So, I'm curious, at what point do we call this a actual lack of due process, even though the INA allows it? Because they're all kind of working together, the IJs and Department of, and the immigration are working together on these cases. But that's why they're firing these folks, is to get out people who might be friendly towards immigrants.
I wouldn't say friendly, at least they follow the law.
Yeah, that's
Yeah.
true.
So definitely, people who are planning to file the cases, even if you have been a clear case, we definitely want you guys, everybody, to go through law firms don't file by yourself, though. Coming to the topic of notice to appear, we do have a daily conference call where people can attend, and there are a lot of people who are coming and they're very scared of this notice to appear. As we were the first to announce about 1.5 months ago that the people who are on H-1B who got laid off and who have either moved to H4 or filed the B2 or filed the H-1B transfer or on adjustment of status. And in one case, the person even left the country, they were being issued a notice to appear, even though they have taken the corrective action within 60 days. Now, the people who got the notice to appear and the people who are getting the notice to appear is less than, it's about 2 to 3% of the people who are getting laid off. It's not like a mass scale going around everybody, like the way what happened with the student visa people where civis got terminated, where anybody has any time, any record with the police, they got their civis terminated. We initially started getting one, two, and then all of a sudden it just blew up. But it's not happening the same way with the NTA. So a lot of people ask the question, what do I do to not get an NTA? I mean, there is nothing you can do. Even if the best maybe is for you to leave the country, which I don't know. If I were you, I would not do it. Because legally you're allowed to stay up to 60 days if your N94 is still valid. Even if the company withdraws H1B, you can file a B2, you can file a H4, you can file a H1B transfer within that 60 days. Absolutely, that is allowed. But the notice to appear is getting issued now. Now it's very expensive. It's not easy to deal with the notice to appear. The cases that went to the immigration judges, they are dropping these notice to appear where the case is getting dismissed, but it's very expensive. People ask me this question, how to avoid this one completely? There is nothing you can do to avoid it. It's
Yeah,
not spreading around. Go ahead, Stephen.
no, the issue with this is everybody's kind of in a catch-22 situation. When an employee is terminated from a country, excuse me, from a company, the company is required by Department of Labor regulation to notify USCIS, and USCIS automatically revokes the H-1B. That is a mandatory process. And, for how many years has that been not an issue? It happens. The individual then is in their 60-day grace period. But because they have the revocation of the petition, USCIS's system was flagging it. Now, I will say, Rahul, I mean, I think because of some of Emily Newman's efforts here from our office, we've
Yes.
seen this slow down. I feel like the last few that we've seen are older. They're not like still getting new ones. I didn't see any like from this past week that were issued this week. They were all mid July. And so I do think that that might have helped. Hopefully, you know, and she spent a lot of time on that communicating with them. So I applaud her efforts on this. But it is something for people to still um, be aware of as out there.
Um, yes, definitely. The USCIS did respond. If anybody wants to support what Emily has been doing by contacting the USCIS, even if you're a victim or not, we want you to go to rnlawgroup.com. She has put a very good information. So, as Stephen has pointed out, that it's not spreading around, it's minimizing. There are some one-off cases we are seeing right now. So if I were the person who got laid off right now, if I'm just 60 days, I am not going to leave. I'm not telling what you have to do it because sometimes it may affect you, but this is what I would do if I were you at this point of time. Yeah. And if there is any progress on that one, we will let you know. Please keep tuning into our YouTube so that we keep updating every week what's going on. Now, Stephen, what are the records that the USCIS has? Do they have the records of the payroll of the individuals? Do they have the payroll records of the STEM extension people? Do they have the payroll of the H-1B? Do they have the payroll of the people who are in adjustment of status by the USCIS?
I think that's certainly coming. I mean, look, President Trump just fired the IRS head partially because they didn't want to turn over payroll, or excuse me, certain tax records in order to immigration. I do think they have access to those. Some of those are reported to immigration, whether it's a request for evidence. You know, if company A received a request for evidence on ability to pay and submitted their tax returns, or gosh, I mean, they might have submitted it with the H-1B and submitted their tax returns. You better believe that USCIS is probably keeping a record of it. So I do think they have a record, and if they don't have a record, they will. The administration is trying very hard to get that record.
I believe that when the first term of the Trump administration, the court wanted to get the records from the IRS of the Trump income tax returns, he fought tooth and nail for them not to be given. But anyway, coming to the immigration part, though, he fired the IRS chief because he's not giving the records. Especially with the Palantir software, which have a lot of tentacles, which we don't know what the legalities of them are. And definitely, I believe recently when I'm seeing RFEs, I believe that they do have the IRS payroll records. The USCIS does have the payroll records.
Yeah,
Now, anytime,
I
super.
always tell people with records, assume USCIS has it, right? Like they have way more information and access to information than we think. I again, if somebody's like, oh, you know, would they know if my company accidentally missed a paycheck, you know, when I first started my STEM OPT? Would they know? Probably. You know, so just I assume my assumption is they have it.
Sounds good. Let's go to the next one. Dignity Act. Why don't you update with me what's in the Dignity Act, Stephen?
Yeah, the Dignity Act is a bipartisan bill. The Dignity Act of 2025 is a bipartisan bill between Representative Maria Salazar, she's a Republican out of Florida, and Representative Veronica Escobar, she's a Democrat out of Texas. Now, I've had meetings with Representative Escobar's office before, and I talked with the staffer who helped write the Dignity Act of 2023. The Dignity Act of 2025 is a rehash of that with a little bit of changes. Now, the Dignity Act kind of creates three major functions. It's enforcement, family unity, and fixing the backlog. Okay, are kind of the big things. And there's some student and visa reforms. Now, this is going to have mandatory e-verify for employers. There's going to be a new system and higher penalties for e-verify. There's going to be certain things to help people that are married to U.S. citizens. But on the backlog, because I assume that's what a lot of our listeners want to know, is it creates kind of a system where the goal is to eliminate the employment and family-based backlog by 2035. This is going to be done a couple of ways. One, increasing the cap from 7 to 15%. So that's double. It would also not count spouses and children for employment-based green cards, I'm not sure on the family-based side, but definitely for the employment-based side, which realistically, Rahul, is doubles the amount of green cards issued. Right now, a family, typically the primary individual is married. They typically have at least one kid, maybe two, maybe four. And everybody gets a green card and gets counted. And that's the big hurt on the number of green cards available each year. But also, what they do is create a processing type fee where if you've been in the backlog for 10 or more years, you can pay $20,000 to get out of the backlog and get your green card issued. Right now, this bill, Rahul, is in its infancy. It's not even having debate or anything. It was introduced a little more than a month, a little less than a month ago. But it has 21 sponsors on it. This is a pretty solid divide between Democrats and Republicans. Because one of the interesting things is that it tries to do some bipartisan. We're going to be tough on the border, tough on employing people who aren't authorized to work, but also create some paths forward to improve our system. Now, this is my position is people need to be contacting their representatives, get in touch with them, advocate. But Rahul, when I told you the Dignity Act, I messaged you and I said, "Oh, this is pretty cool." You just threw cold water on me.
I didn't study very much about the Dignity Act. The reason, Stephen, is that it's the Trump administration right now. And right now, the Congress, the House of Representatives is in the hands of the Republicans, and also the Senate is also in the hands of the Republicans. And the president is anti-immigrant. And you know that Stephen Miller, who is the immigration advisor, did not put his weight on this bill. If he would say, Stephen Miller comes and says, well, let's pass this bill, I would definitely be interested jumping up on this one. And definitely this Dignity Act, it's going to increase the numbers by more than double, I would say, because and definitely it's going to clear the backlog in less than 2 to 3 years, significantly at least, if not fully, significantly 2 to 3 years it's going to. But I do doubt very sincerely that this is going to be passed, even if it's going to be passed in House and Senate, very unlikely at this point of time. I would give this bill less than 1% chance, and I would not like my people to put all their efforts in this. That's my opinion. I know that you want people to contact the congressman. That's your opinion, Stephen.
Yeah, I don't think it's going to hurt anything. Like I said, I've been part of some organizations here in Houston that have had meetings with representatives and had one with Representative Salazar. I also have a meeting coming up, I think next week, with another Texas Republican and a New York Democrat that have kind of built their immigration platform that they've been trying to on the businesses, Bibles, badges. That's what that congressman has told me he's building it on. And it's kind of trying to bring some reform on both sides. Hopefully, I will say this. To the extent that reform is going to happen, I do think there is a appetite for that in Congress because the system's messed up. And I had meetings with Democratic representatives during the Biden administration who's like, this whole system's messed up and needs to be reformed. And obviously, Republicans have their opinions too. How much good we are going to see is going to be seen, but in order to get some of the numbers that they would need, it is going to have to be a bipartisan effort and agreements between multiple groups of people. So I agree, Rahul. I'm not sitting there holding my breath on the Dignity Act, but make those phone calls, write those letters. I know we tell you that every year, but it doesn't hurt. And, try to, maybe your letter does it.
You never know. Sometimes the Pride did move 4 or 5 years in the Trump administration last time. Who knows? Stephen,
Yeah.
things may happen. We go to questions, Stephen, unless you have something else.
No, I think we'll get to questions. And so, actually, real quick, one of our first questions, Raul, I think does need a little bit of a discussion between you and me. The new Child Status Protection Act interpretation by USCIS CSPA. I know you and Ryan did a really dang good video on that when that was announced last week, but that was one of our first questions on here is kind of how that works. So what's changed with CSPA?
In the Child Service Protection Act, previously they used to only consider the final action dates. Stephen, there are 4 things that need to be aligned at the same time. The final action date has to be current. The I-140 must have been approved. The 485 must have been filed. The child must be under 21. And of course, any time period the I-140 will be pending will be added or deducted. How you do it, it's different. So for example, if the I-140 is pending for 6 months, the child will become 21, not when he becomes 21. He will become 21 when he becomes 21 plus 6 months. So in other words, child should be under CSPA 21. 485 must be filed. Prior date has to be final action as it is established to current, and I-140 must be approved. Now, of course, the Biden administration did change, saying that even if the filing dates are current, then the person's age will be locked. Now, Trump administration reversed it, saying that it's going to be only final action dates. It's not going to be it's not going to be filing dates. However, the Trump administration said only going forward. So the people who are already locked are already locked. The people who are not locked, for example, they will not get locked going forward. So that's where the issue is. That's where the things have been changed right now.
Yeah, and I can tell you that was a big relief. Like when I saw that, started reading that announcement, I was like, oh God, this is a mess. But at least they committed to it's going to be for cases filed like after August 15th only. So anybody who's already filed and locked in doesn't need to stress. And so that's the one positive.
Stephen, I want you to comment on Yogesh comment from the X Twitter. Is asking, why don't you tell me about the next year lottery?
I don't have any details on it. Now, what we do know is that we should be seeing a proposed regulation anytime now. It has cleared the review for a proposed regulation to be out to change how the H-1B lottery is done. The H-1B lottery is done with the pre-registration in March. They run the lottery the end of March. We get the 90 days to file the H-1B. USCIS, or in the first Trump administration, tried this rule, and it sounds like they're trying it again, where it's going to power rank, and that's kind of been the best way to describe this, higher wages for better chances in the lottery. How that works in the system, I don't know. If it'll be weighted, how are they going to ensure compliance? Because you don't submit anything. I don't know. We'll see with the proposed regulation. That would be a major change. I would also expect it to be litigated, Rahul. It was litigated in the first Trump administration. The judge took the quite honestly easiest way out to get rid of the rule. In that at that time, Chad Wolf, who was the acting head of Homeland Security, didn't have the proper authority to sign that regulation, and so that's an easy way out. Judges always like the easy way to get rid of a case, right? And so if they can get rid of the rule because he didn't have authority, and a lot of people had already ruled he didn't have the authority to do that kind of thing, they don't have to get to the merits of it, because the INA, Rahul, says that H-1Bs basically have to be issued for the cap in the order in which they are filed. Now, we know for years that's impossible, and they've created the lottery. The lottery is a reasonable interpretation of that. I do not think the wage power ranking is a reasonable interpretation. I'm all for it. I want people to get paid as much money as they can. That's great, but I don't think it complies with the Immigration and Nationality Act.
So, according to your expectation, it may not become law, the new regulations, what they proposed it.
Yeah,
That's okay.
I don't think so, but it
But
is something.
what is going to be in the regulations according to your expectation as the US is going to publish it?
I keep forgetting to go back and look at the old one, but because I'm curious on how they're going to differentiate, right? Like a level a level one wage in San Francisco is like double the same job in Missouri, right?
Mhm.
A level four wage in Missouri is less than a level one in Los Angeles. Um, how they differentiate between that and occupations, maybe a individual who's at a startup is going to have a lower salary than somebody who's working at Facebook. I get the idea behind it. Higher salary should govern, but that doesn't always mean the most value. I mean, a doctor, right, in a rural Waller County, Texas, is not. It provides good value differently than someone who has a level four wage. And so it's just something we're going to see how it works out, how they go through. I'm very curious on how they do this from a practical side. Like put the law out of it, how the practical side is, because right now we don't submit any documentation with the lottery. So do we have to submit an LCA? Well, what if companies amend, right there on October 1st? What do we do then? And so I'm curious to see what the proposed regulation says that's going to combat those issues and still keep the efficiency of the current H-1B lottery.
Say is asking this question. He got a green card last year. Is it advisable to work for two remote jobs? I don't see anything wrong in it. In fact, when my wife got the green card, she started working for 8 companies at the same time. Especially in the healthcare industry, people do work for multiple companies at the same time. I don't see anything wrong in you working two remote jobs on GC. You already got the green card, so you're fine. No problem with that. You don't need to do any paperwork.
Question about employers. Look, I can't speak to your specific situation, but if your employer isn't paying your wage, you need to contact an immigration attorney. Full stop.
Question with regards to, will there be any changes in the N400 for the employment-based applications? Well, at this point of time, we're not expecting any changes. Don't give any suggestions to the administration for the changes. This question is from VVW, but nothing is expected. One, we are noticing that increased amount of people who are filing the N400 citizenship application right now because of what's going on with the Trump administration. People are not comfortable staying on the green card, so we have seen an increase in the amount of people that are applying for citizenship. But we haven't seen any changes in the citizenship application, especially for those people who got the green card through employment base. This is coming from VVM from YouTube.
Question from Achanta here on YouTube. Has a green card interview scheduled September 2025 at the Raleigh field office. Priority dates December 2012. Downgrade from EB3. Has EB2, EB3. It's kind of our typical situation. Anything to be concerned about? Rahul, are you seeing any new trends on green card interviews? I mean, I know I've done a few over the years. I've talked to plenty of people. I haven't seen anything. Maybe the officers like attitudes. They're a little bit more. They're jerks, but they're not changing
Yeah,
adjudications.
they're kind of asking more questions with regards to how did you get the
Yeah,
job in general.
yeah.
But as such, we have not seen any peculiar denials or RFEs in the 485s, though. In fact, I've been getting calls every now and then that if the people who have had a EB2 pending, but their priority date is currently in EB3. In fact, I just got off phone with a USCIS official. The guy was asking me, "Hey, have your client write a letter to me saying that please consider me in EB3. I'm going to approve this case right now." That's what the officer said. I just got off the phone. I just called the client immediately so that he can just send the notice, put it in the FedEx right now. He gave me the address and everything. So otherwise, I haven't seen him, and adjudications are going normally at this point of time in employment based.
Yeah, and we've done. I get this question a lot, Rahul, when we do litigation on 485 delays. Like, somebody says, "I have no clue if I'm on EB2 or EB3. I did a downgrade to EB3, then I upgraded to EB2, then I did an interfiling and another interfiling." The way I kind of take it when I do my 485 delay lawsuits, Rahul, is I kind of say that the individual is current under one or both categories and they have approvals for both categories. And quite frankly, nobody really cares if they're EB2 or EB3. And so, in those, sometimes we just get it. It's pretty straightforward. Other times they'll say, "Hey, we just need a TUB letter, transfer of underlying basis letter." But we've had good success with kind of working on that with green cards in delay litigation.
Question from Kishore Bandari is asking, do you still advise people to file H1, H4, and EAD together? And yeah, we still advise people to file it together. There are a good number of cases that are getting approved together. There are some cases that are not approving together for sure. But you have more advantage, more chances for getting approval along with the H1B. So we still advise people to file H1 and H4 in EAD together.
Yeah, I filed a lawsuit on one of these. I mean, I'm still seeing good trends, but I need to get back to tracking it more thoroughly. Question on YouTube here: are we seeing more 221G notices for H1B interviews for full-time employees or just third-party clients? I had a call today with an individual that has a 221G and he has been pending for quite a while, and he is not a third party. I think they are doing more of them, but it's kind of to be expected. It's why we don't always recommend travel unless it's necessary.
Same question is coming from Ashish. Is it risky traveling for stamping if you are scheduled to interview in October? Absolutely risky. Now, let me tell you one thing. If you are going for stamping, what is my advice? No, 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 no. 13 times. No. It's
I,
don't repeat. I every single day I get a call. I got a 221G. I got this. I got that. I got stuck in India. Why could not you have told anything more stronger than what you have already told? I don't know what to tell. I mean, I can't take a gun and go to people and tell them not to go for interviews, not to go for visa
yeah,
stamping. I wish I
it's
could. If they allow me to exempt me, I probably will go with a gun, but it's not allowed legally to do that. If it is, I will.
Yeah, it's definitely tough. I hate having that conversation, but I do think, there is a risk. And whether it gets delayed, like I said, I just talked to an individual today. His has been pending for 18 months in administrative processing. Whether they deny it, there's not a lot we can do when denials at visas occur. And by the way, the F1 students, Rahul, I'm hearing a lot of visa denials on them. So try to avoid it if you can, because we can't sue on visa denials. We just can't.
And we do see every single day denial in the consulate or 221Gs. The problem with the 221Gs is that By the time they get cleared by that, you lose the job. And we tell people, withdraw your H-1B application. You don't have the job anymore. So you can't come on that time because then they're going to deny it. So we tell people to withdraw their applications. So definitely not a good time. Now, the other thing right now, what Stephen has pointed out was that the immigration judges got fired because they were giving the proper judgment. Now, think of this one. What will happen to the consular officer who are giving the visas?
Yeah.
Yeah, and that's how the situation is right now. And people ask the question, why would they deny a full-time job? I got a salary of $150,000. I got a job with a FANG top company in the United States. Well, simple. They're jealous. Look at what Stephen Miller is telling. Look into what Mega PAC of the Mega, that's the organization that is in support of the Trump administration, that how they come into power. What they're saying is that that these Indians should not be hired, Americans need to be hired, and that's what they are telling the reasons. So definitely they are jealous and they don't want to give an approval because of your high salary. That's how the administration is. So be careful when to choose to go for stamping.
Yeah, and obviously things happen. Obviously, if you have a legitimate immigration reason, if you've got a denial, we're not telling you to hang out in the U.S. unlawfully. Like, don't do that. Um, but gosh, Rahul, I think if I had $1 for the amount of people there, so my visa stamp's expired, so I'm going to travel to get it renewed. Like, please don't do that. And then, Rahul has a little different view than I do. Like, I understand people with family needs, I get it. You got to make that informed decision at some point. What is the risk to you if you get stuck abroad to go to a funeral or something? And I know that sucks. I hate having that conversation, but a lot of risks involved.
SA is asking this question from YouTube. He got a speeding ticket at a school zone. Tesla autopilot. Bad luck. I'm a big fan of Tesla. But he has paid the penalty, and will that cause any problem for the USC immigration process or citizenship process? Absolutely will not cause any problem. What we have seen people where things like small speeding tickets that got into trouble are when you neglect it. If you contest it and you get dismissed, I'm fine with it. If you pay it, you get it dismissed it, that's fine. But if there is a speeding ticket or some ticket given to you and you do not respond to it, you ignore it, then you get an arrest warrant. That gets into the record, then you have to report it everywhere. But if it's just a small speeding ticket like yours and you already paid, or you challenged and got it dismissed, either way, it is fine. It's not going to cause any problem.
Question I just saw here. Where is it? Oh, global entry. Is it advisable to go to an interview for global entry? I have not had any issues with global entry. When you get called in, by the way, forgot mine had expired. So, just and renewed it when I needed my pre-check. When you go through, they conditionally approve it and then you can schedule the interview. So typically you don't have an issue when you do the interview. When I did mine, it was like a quick little 10-minute thing. I spent more time trying to find parking at the dang airport. So you should be fine there. If you have an arrest warrant out, maybe don't go. So yeah, I think you should be fine though.
SA is saying that I'm not driving, it's the autopilot that drive. Yeah, but that's either way. You are responsible for the autopilot at this point of time, guys. So since you are sitting on the wheel, you are responsible for it. You're supposed to control it. So don't argue that very much. Just say that I did a mistake. That's always better.
Yeah, I've never, had issues with people with traffic tickets. The people we have, like you said, the extreme, like going 70 miles an hour in a school zone, yeah, probably. But if you weren't put in handcuffs, you're probably fine for anything moving forward.
Yeah,
Unless Elon becomes an enemy of the state, Rahul, and then Tesla's,
yeah, yeah. I bought Tesla in 2018, so I'm pretty aware of it. Big fan of Tesla. But still, it is your responsibility if you have gone over the speed limit, guys. Um, question from
Question here
Sam.
from. Oh, go ahead.
You go ahead, Stu.
A question from Srinivas. H-1B extension filed before I-94 expired. H-1B extension was denied 120 days after the I-94 expiration. Left the U.S. Later, H-1B and green card was approved. Yes, so that was the I-140. Will I have issues at the port of entry due to overstay? Not typically. I mean, you are in a period of authorized stay during that 120 days, and you got the visa later, you should be totally fine. It's never been an issue in the past.
Sam is asking the question. He recently got the green card about a month ago and he wants to quit the job. Will it affect the naturalization? Absolutely not. I mean, when I said is that you can quit the job, it will not affect your citizenship at all. Even though you got the green card 1 month ago, it will not. And will this be any problem for you to travel if we quit the job? Absolutely not a problem for you to travel.
Good question here from Adam on YouTube. H-1B was approved recently, but I'm not planning to go get it stamped right now. Is there any problem if I don't get it stamped? What about when I have to renew? So if you have never been counted against the H-1B cap, meaning, you go through the lottery and you don't get the change of status approved, then you do have to get the visa stamp in order to activate it. But if we're talking about your extension or you got the change of status approved or whatever, no issues at all. You don't have to have it. The visa in your passport, the visa foil is what it's called, is only needed to enter the U.S. That is your approval to seek permission to enter the U.S. What you have when you stay in the U.S. is the I-94. That's what governs. Your visa could have expired 20 years ago. As long as you have maintained your status and had an I-94, you are totally fine. You just have to get it if you travel.
Vinod has this question from YouTube that he got an I-140 approval and the SOC code says 0000000. Will that cause any problem at any point of time in extending the H-1B? Or we have noticed that in a couple of I-140s. I don't see that it will cause any problem whatsoever at all for you to extend the H-1B, use it for H-4 EAD, put the date to some other company. I don't see that a problem at all. Question from Reddy R. When I changed my employer, my previous employer kept the original I-140 approval with their attorney. Could you please advise me how to best obtain the physical original copy? This, Mr. Reddy, you don't need the original I-140 approval for any purposes whatsoever at all. If you have a copy of it, that is good enough. You don't have to worry about I-140 approval. Now, in our office, we just keep a scanned copies and throw them out. I mean, why do we need it? You don't need it. Original I-140 approval for any purposes, though. You have a copy, that you're good.
And if you don't have a copy, you can always file a FOIA request, Freedom of Information Act online. Ryan Wilk from our office wrote a good article about that. It's pretty easy to do, but Rahul's right. I think I was practicing for 2 years when I ever knew people actually wanted the I-140 approval, because we had a stack of in our office because it's the scan is totally fine.
And even if people give the original certificates, I mean, USCIS is not going to believe them. They always check in their database to if it's original or not. Here is an interesting question that is coming out with regards to the people who are unauthorized working on F1 getting married to U.S. citizen. Definitely, we need to be very careful whether we should file the application, timing the application. Definitely, it may be transferred to the immigration court and back. So you need to be prepared for all those things when you're filing the 482 application.
And another, thing to, think about is if you can go do the margarita visa and come back in, if your visa is still valid, cure the defect by traveling, coming back in, and then look at from your last entry if you maintain status. So I wouldn't go for visa stamping in this situation, but um, if you've got a valid visa, you could do the margarita visa that Rahul loves to talk about. Um, cure the defect that way.
Yeah, it's something that should be considered. Okay. Yeah.
I'm trying to find it.
Abhishek Chaudhary has this very interesting question. He's about to reach the seventh year on EB1C. His priority date is March 2024. Of course, he cannot file the 485 because he's an Indian national and the priority date is not current. What are the courses of action? Definitely, if you can think about filing an H1B in the lottery. That's if you have not completed 6 years, that's something that can be done. One thing, Abhishek, that I want you to be very careful right now is to be in good terms with the company, though. Because even if you max out on 7 years, if you move out to a different statuses, if your company does not cooperate, then you won't get the green card eventually, though. Now, there are ways where you can get transferred back to your home country, still stick with the same company, and then still get the green card. Either you get the green card in India, you come back again on L1 and get the green card, though. So, one thing I want to pay very good attention is to be in good terms with the company, then look into the alternative things, whether H1B, changing to F1, changing to B2 for a while. B2 may not be a good option. It's only 6 months that is available. Or going back to your home country or any place with the same company and coming back, maybe the best option is to go outside the country, because to be in good terms with the company so that you can come back and get the green card, or even get the green card in the United States, outside the country.
Rahul, we have a lot of questions on priority dates. When is F2A going to become current? When is EB1 going to become to 2017? Y'all are barking up the wrong tree. Rahul and I are not able to guess the visa bulletin. Now, I can tell you probably next month we should have the October 2025 visa bulletin, and that'll give us a good look ahead at fiscal year 2026. The government runs a October 1st to September 30th fiscal year. And October 1st each year is where we see the biggest movement on forward on the visa bulletin. At that time, Emily in our office she's good with numbers. She'll look at the inventory and how much it's moved, and we might be able to make a little bit of predictions on this, but it's really hard to predict the visa bulletin. I have no idea what date, what USCIS is working with on all this. So sorry we're not touching base on all your questions. I'm hoping we see some good progression, though.
Especially for the people who are a 2017 Indian National CB20 B3, it's definitely not coming next year. I
Yeah, and
sense.
I've talked with a lot of folks, Rahul, on this, not just attorneys in our office, but outside. This is where, if you qualify for EB1, whether it's EB1A, B, or C, that might be something to kind of help, especially, as things don't progress. EB5 is still current for everybody on the set asides. I don't know how long that's going to stay that way. I know, look, that's a huge investment, but it is something that's out there. So, don't get pigeonholed. Look at some options, and with EB5, there were some changes in the law that allow you to use loans, use like a home equity loan, especially with housing prices going up, or a bank loan or something like that. So take a look at EB5 potentially.
Questions with regards to this question is coming from Gaurao from YouTube. Is asking the question, for the people who already have the passport stamping, do you see any on the H1BC speaking about? Do you see, if people are traveling, are you seeing any problem? No, we're not seeing any problem if the H1B approval is already stamped, unless there is something specific about you that is standing out, about your criminal record or anything that is very odd. Otherwise, normally we don't see any problem in people traveling outside the country. A little bit more scrutiny, but in general, 99% of the people are going through very smoothly.
Yeah, and there was a rumor, Rahul, about like an Instagram post or something where a lady was denied entry because she had worked in India. Um, and I have heard from one attorney that had issues at the consulate, and then they contacted LegalNet, and that was cleared up. I just had a client that had to go overseas in April unexpectedly because of a family emergency. Um, Worked from India, and he came in last week, didn't even get asked about it. We had prepared a letter kind of explaining what happened. I think that's a rumor or a bad experience with an officer. There's nothing that prevents people from working outside the U.S. This interpretation of, oh, it's not on your LCA to work in India. Well, like, of course not. You can't list foreign addresses on the LCA. So that's either uneducated officers, but that's I've heard one rumor, Rahul, and I just had a guy come in who was gone from early April until last week, and he didn't have any issues.
It's just, I don't know if the lawyer has any clue what she's speaking about. I looked into the post that she posted. She's telling that a person cannot work without LCA in India. Well, you know what? If you're working in India, you don't come under the USCIS guidelines.
Yeah,
The USCIS guidelines only work until the borders of United States, and India is not the border of United States. Even though Trump is trying to include Canada and Greenland, that's a different issue.
Greenland.
But definitely, India is not on his menu. and
Yeah, I
and when you are in India, you are an Indian. Can an Indian work in India? I also happen to have an Indian law license. I can say fairly simply, you can work in India. Any national can work in their own home countries. I don't know of any nation that does say that you cannot work in their home country, though. So India is a similar. They allow people to work in their home country. Absolutely not a problem. You don't come under any jurisdiction of USCIS. You don't come under Immigration Customs Enforcement. If you are an Indian, you are working remotely into USA, you are allowed to work. Absolutely not a problem. And that person who was got denied, we offered a free consultation. Nobody came to us. That person got denied because he worked for 60 days. That is not true at all. And Stephen has pointed out clearly that his client claiming no problem after
yeah.
4 months that he worked outside the country.
Yeah, last I heard, Parliament and President Modi hadn't adopted the U.S. Immigration and Nationality Act. And I did see here that Abu Dhabi is strictly warning that longer stay in India, H-1Bs for working in the U.S., you can't work for a long time outside the U.S. Like, those officers are morons. I don't know how to say that in a nicer way. I mean, they're absolutely incorrect. When you are outside of the United States, the H-1B, you're not on H-1B anymore. So, yeah, the H-1B is for working in the U.S., but there's nothing in the Immigration and Nationality Act or any regulation or any interpretation of the statute or regulation. I know I've heard the rumor about Abu Dhabi too, but avoid Abu Dhabi, I guess. But I don't. I've not seen this. Like I said, I just had an individual come in, and those officers, if they're doing it, are just flat out wrong.
Question that is coming on. I got a GC recently, but the project ended right now. Can I go to India and come back? Will that be any problem? Since you got the green card, you are not an H-1B, you're not an advanced parole. If you lose a job, you will be perfectly all right. Absolutely not a problem. In fact, it's a time when you don't have anything to visit India and stay for a long period of time and you don't have a job. That's a free period that you got. I don't see any problem. Now, this is only I'm telling for the green card holders. Will I tell the same thing for H-1B who lose a job? Absolutely not. Will I tell the same thing for the people who are in adjustment of status and they are the primary applicant? No. You need to check with a lawyer before you travel outside the country. If you're an F1 OPT or STEM extension, you don't have a job, I definitely tell people not to travel. Since you are a green card holder, I don't see any problem in your traveling. Absolutely not a problem. This message is for SA from YouTube.
Um, let's see here. Okay, good question here. I see this a lot from Lakshman here on YouTube. Applied for H4 EAD, yes, or starting October 13th H4 approved yesterday. Unsure if it's active or from October 13. Can I keep working on my current H1B or should I stop? Rahul, I'm curious your thoughts on this. My thought has always been the online case status doesn't mean anything. In fact, USCIS, I think, used to have a disclaimer that said it has no like legal value. So
Mhm.
until you get the approval notice, what I tell people is that yes, you have constructive notice that your H4 has been approved. And so maybe you could start taking steps to accommodate that change. But you don't know, was the I-94 granted? Was it from October 13th yesterday? The only thing that governs is the actual approval. The online thing is just a tool to help you track your case. It has no legal consequence, and I've never had anybody face issues. If you get the approval on Friday and it says it started today, and you kept working until Friday, I've never had anybody face that issue because they didn't get it into the mail. And that's what actually governs from a legal perspective.
Nick has an interesting question. His wife has an H-1B which is approved, but visa is not stamped. But she has an advance parole. Can she travel advance parole and come back without any problem? Absolutely. She has an advance parole which is valid. She can travel. She doesn't need to go for H-1B stamping. I advise people not to go for H-1B stamping in this particular instant because she is on advance parole. She can come back. When she comes back, her H-1B is still valid. She can still extend the H-1B. She can transfer the H-1B. She can amend the H-1B. So why do you have to go to the consulate to get the H-1B stamping? Absolutely not needed to go for H-1B stamping. This is for Nick.
Recent experiences on the RFEs for biometrics and court documents. I don't think I've seen any denials yet that I've heard of, but you do need to take these RFEs very seriously. They want to, what they're looking to do is deny the extension of stay, deny the I-94. They're going to say that they have discretion to do that. And so when you get these requests for the court documents, put in why they should exercise that discretion. What were the charges? What were they dismissed? Were they whatever? What rehabilitation did you do? Did you go to classes? Did you do volunteer work? Are you an outstanding member of to your neighbors? Whatever. Take these RFEs very seriously.
Couple of things. I just want to let you know that there are a lot of people whose perm, because of the perm, they are moving to H4 plus EAD. What I strongly recommend people is that to do file the H4 EAD way in advance. Let's say, for example, your 6 years H1B is expiring in June of 2026. Is this a right time for you to file the H4 EAD? If you have an option and if your spouse's H1 is expiring, let's say in 2027 and 2028, absolutely it's the right time to file for H4 plus EAD. There are 95% of the time the H4 and EAD will be approved together. And if that 5% of the time the H4 is approved and the EAD is not approved together, there are ways where you can go to Mexico and do a margarita switch and switch back to H1B. And later on, once the EAD is approved, you can switch back to H4 by doing a margarita switch. So there are ways, but don't delay because people contact me in May and they will ask me to apply for H4 EAD and get it expedited. It's not that easy to get the H4 EAD faster. So then what will happen is that when June your H1B expires, you don't have a perm application pending for more than 1 year, and you have to stop working in June of 2026. But if you apply for H4 EAD right now, then you most probably don't have to discontinue working. Okay. Question from Sri. EAD and AP, EAD and AP, can they work in India? Well, guys, look at me. You go to Hyderabad, you go to Pune, Hinjawadi, you go to Hyderabad in high-tech area, you go to Gurgaon in Delhi, there are thousands, if not hundreds of thousands of people. Even in the night time, there are so many people working there. None of those people, or at least 99% of those people, do not have any work permit. They're all working legally. There's nothing illegal for them. They're Indian nationals are working in India. Absolutely, they're allowed to do so. So if you're there, you're not working in EAD, in AP, you're still allowed to work. Absolutely not a problem. You
Now I
can
can't
work.
work in Hyderabad, huh? I'd have to get,
You need to get a work permit, definitely,
but
Steve.
not an H-1B or an H-4, right? That wouldn't matter because U.S. immigration law doesn't apply in India. I'd have to follow
Doesn't apply to
India.
India. Yeah, Stephen, for you, even though I'm a US citizen, Stephen, I have a something else, kind of green card kind of thing. It's called OCI, Overseas
Yeah.
Citizen of India. So that allows me to go and work, but you need to get work permit, definitely.
But yeah, I
But
mean, truthfully, this comes up all the time, and you know, I make a joke there about me needing a work permit, but to work in India. But we get this question a lot. There is no requirement to comply with U.S. immigration law. Now, there might be tax consequences. There might be other consequences when you're outside the United States. Because it's not U.S. immigration. U.S. immigration is all about where you're physically sitting, right? And so when you're in India, it doesn't apply. I know there are some officers at Abu Dhabi who may or may not be
it
doing
did
this,
not happen, Stephen. It
but
is
yeah,
just some
it's
fake news. I don't
again, I've
believe it
heard of
because I never spoke with them.
no, and I've only seen that one rumor. I just had a guy come in, no issues. So don't stress about it when you go abroad, whether it's Europe, whether it's whatever. You know, make sure you have the right to work where you are, but you don't. You know, it doesn't impact your H-1B. In fact, quite honestly, Rahul, if you're on H-1B, you can recapture that time spent outside if you
Even though
need.
you continued working, though.
Yeah. So
Yeah. So let's say, for example, you have 6 years of H-1B, but you work 4 months in India. Like your gentleman, that guy went from April to August, he went and he came back. He can recapture that time, even though he worked for the company, even though he got paid for the company, he can recapture that time, saying that, hey, I haven't used up my 6 years. 4 months I spent outside the country. Yeah, you're right. That's a very good point.
So obviously, immigration doesn't think it's H-1B when you can recapture it. So, but you know, I get that question a lot. I know people are panicked about the one social media rumor. I haven't been able to substantiate it. So just if we see something, we'll say something.
Sri is saying that he heard from another lawyer not maintaining other status when AOS spending is not recommended. I may disagree on that thing, especially in the employment-based immigration. I may disagree on that thing.
Yeah, I think there's different strategies different lawyers would have. I mean, I don't think they're wrong. There's nothing wrong with maintaining your non-immigrant status. I don't necessarily think it's needed. If your immigrant visa petition is approved, the I-140, the 526 is approved, and the EAD has been approved, there's nothing. Once the 526 or the I-140 has been approved, I think you're okay. If I wouldn't necessarily recommend it if you're waiting for the adjudication of the 526 or the I-140.
Ajax is asking this question, and I am not a finance guy to advise. I'm just advising only in the immigration part of it. He is having, I'm assuming that he will have a main job on H-1B and GCEAD, where he's a primary holder. On the side, he is going to do day trading. That is, he will do multiple trades in the stock market. Will that be a problem at the time of, will that be a problem in getting the green card? Absolutely will not be a problem. You can do day trading. This is only as an immigration advisor. I am not advising based on the financial things, which I'm not good at it. I'm not good at it. I did day trading and lost all my money a long, 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 long time ago, 30 years ago, and I never ever did it. But that's finance side. As far as immigration side, you can. I don't see any problem. Anything else, Steven?
No. And again, I understand lots of questions. We're trying to keep on top of it. One thing, you know, Emily Newman and I do a podcast, Visa Vibes. We do it weekly. It's on YouTube, Spotify. Apple Podcasts. If you have a topic you want us to suggest, reach out to us at the info email or reach out to us on social media. We're always happy to talk about what people want to hear.
Do you have any particular subject that you're doing this week, Steven?
Yeah, I think the one that came out today was on the Dignity Act, maybe. Ironically, and then this upcoming week we're doing one on kind of preparing for delays in immigration context, best practices. We're already starting to see some trends on the Trump administration, so we've done a whole bunch of them. If you have anything that you want us to discuss for a 30-minute podcast, happy to do it.
Thank you very much for tuning.